Thank you, Susan. Good evening, everyone. Welcome to the Forum on Law, Culture, and Society at the 92nd Street Y. And this is yet another year of the Law of the Land, the Supreme Court Year in Review. This is wildly popular for some reason. Every year, Kenji and I have done this now for 3 years in a row. People come out, and it's fascinating. I think the Supreme Court is filled with endless mystery, and we have a president who wants to somewhat demystify it, and we'll talk about that today, perhaps. But it's so great to see, most of you are civilians. There's not everyone's here for CLE credit. So there's obviously some interest in this, and it's really nice to see. And we hope that this is all about making you all walk out of here a lot smarter, and then you hear President Trump, and he'll change that. Now, this is the first time in 20 years that I've been here that we're going to have to watch television after. Like, we've never done that. I should have had you bring pajamas. We've never had anything like that. We all tell horror stories after. Some of you might think the Trump administration would be that as well. This is an enormously interesting night because there is a kind of pageantry and high drama that has been added to this. And I'm not even sure if that's a good or bad thing. And I may ask our panelists whether they actually think it is a good or a bad thing. Maybe, in fact, the president has demystified the court. We'll talk about tonight's pick a little. We'll talk about the absence of Justice Kennedy. We'll talk about some of the key cases. But first, and then of course we'll watch President Trump announce the pick. And then we'll have two of our panelists will stick around and perhaps give their own commentary and answer some questions. Let me just briefly tell you who we have. Yet again, another all-star panel. Yet again, always, the one person that's always with me on stage is Kenji Yoshino. He is a colleague of mine at NYU Law School. He is a first-tier constitutional legal scholar. He's also an incredibly eloquent person on the law, which is why you see him often on major cable networks. He is the author of a really wonderful book, Speak Now, which is about Hollingsworth v. Perry, the marriage equality end of Proposition 8. And it's really, in many ways, a memoir and a book about that case. And it's wonderful having Kenji back. Please welcome Kenji Yoshino. Our next guest is a truly esteemed, distinguished, and fearsome New York lawyer, Roberta Kaplan, truly one of the... And as you've just heard, also a rock star on the side. And that comes from not just being fearsome, it's for being righteous. She became a household name, and certainly in this room she is, for having represented before the Supreme Court Edith Windsor in the case United States v. Windsor. That was the case that invalidated key provisions of the DOMA and ultimately led to Obergefell and the invalidation of all impediments to same-sex marriage. And it all started with Robbie's incredibly righteous crusade on Miss Windsor's behalf. She, too, is the author of a book about that experience of handling in that case that also has memoiristic elements that I love about it. That book is entitled Then Comes Marriage. And welcome, Roberta Kaplan. And last but not least, my friend Ron Klain. Some little boys want to grow up and be Mickey Mantle or Derek Jeter, and then there are those who want to be Ron Klain. I was one such boy. His career is really extraordinary. Your mouths will just start going, what? He couldn't have done all that. He's now a political commentator for MSNBC, so he's recognizable to you there. He has a column for the Washington Post. But in younger incarnations of Ron Klain, he was senior advisor to both President Clinton and President Obama. He was the chief of staff for both Vice President Al Gore and Vice President Joe Biden. He was the general counsel for the Senate Judiciary Committee. He was the general counsel for the Bush v. Gore Recount Committee. And
on the Gore side.
On the Gore side.
Yeah.
And you know this because if you saw the HBO movie Recount, it was, what was his name?
We don't say the name
We
anymore.
can't even say the name anymore.
No.
We can't say the name. It's politically incorrect to mention his name, but he actually played Ron Klain in that film. And you know what? This is kind of a weird Freudian moment because I'm not deliberately not saying his name. I can't remember it right now. But it'll come to me. But actually, he was too old for the part, honestly.
Yeah, no question.
He was, I first thought, I said, Kevin Spacey. Kevin Spacey was 15 years too old for this part.
Totally miscast.
He was, in addition, has been both President Clinton, President Obama's, and Hillary Clinton's debate coach for the presidential debates. He was the Ebola czar in the Obama administration. And here's the one that I think is really incredible, is that through his work preparing confirmation hearings when he was in the White House, and in his work as general counsel for the Senate Judiciary Committee, he played a role in both the nomination and selection of 8 Supreme Court justices.
Yeah.
That's nuts. Like, that's Ron Klain. Oh, and there was that one year in 1992 that he did play center field for the Yankees.
Yeah, exactly.
So let's start out. Let's start off with something before we get to the cases. I'd like to have a few words about Justice Kennedy. How greatly missed will he be? This is a panel full of, this stage is awash with liberals. It's crazy how much, this must drive red states crazy to watch this on the live stream, but this is awash with liberals, and yet this room, this stage, might have very positive things to say about Justice Kennedy. I wonder if some of you would like to join in on that discussion.
Well, I'll start. I mean, I think, look, I think Justice Kennedy, particularly in the later parts of his career, turned out to be a more conservative justice as his career progressed, and certainly reached a number of decisions that I strongly disagreed with. And in fact, if you look at this past term, the court decided 63 cases. He voted with Chief Justice Roberts in all but 6 of them. So you might say, well, Kennedy leaving the court, how big an impact will that really have? If Roberts is the swing vote, Roberts and Kennedy agreed 90% of the time. Nonetheless, I do think it's going to be a major change at the court for a couple of reasons. I think that at the Supreme Court, 4 justices can decide to hear a case. And the 4 very conservative justices probably declined to bring some cases to the Supreme Court because they didn't know where Justice Kennedy's vote would be. Or after they granted cases, those cases didn't go as far to the right as they could have been in their reasoning because Justice Kennedy held them back. So I think even if you look at his vote, you look at some of the conservatives' votes, he has been a constraining force on the move of the law to the right. And I think whichever of the 4 President Trump picks tonight, the court is going to move significantly to the right with the departure of Justice Kennedy and his replacement by someone in the mold of Neil Gorsuch, which is, I think, what we're looking at tonight.
I can't help but think Kennedy writes I'm sure he did, majority opinion in Bush v. Gore. Right?
Well, but perhaps.
Yes.
Yeah. I mean, it's a per curiam. It's not signed, so we don't really know.
Not signed, that's right. But I mean, saying there's a case that affected you directly in every way possible. And yet there's so many ways to look at this man's career, including one that was so pivotal in your own life. For you two, I think similarly, I don't know if it would be inappropriate to say that, at least from the Supreme Court's perspective, he could be the architect of marriage equality. I mean, do you think that this is something Ronald Reagan had in mind when he nominated Justice Kennedy, that he would be using the words dignity, throwing it around in judicial opinions when it comes to same-sex marriage? I mean, I find this extraordinary.
Yeah, I'm not even sure it was something Justice Kennedy had in mind when he was appointed to the bench, but Ron, and you're absolutely right. Justice Kennedy had a very idiosyncratic and at times unpredictable jurisprudence. But in the area of gay rights, probably no Supreme Court justice has dominated an area the way Justice Kennedy dominated all the cases having to do with the equal dignity of LGBT people. In Romer, Lawrence, Windsor, and Obergefell, he wrote all 4 of those opinions. And he, for whatever reason, I think it has probably something to do with his deep Catholicism. He had a very strong jurisprudence of dignity and of human dignity, and of this concept that all human beings, that we have in Judaism, that all human beings are created in the divine image. And it translated for him, ironically enough, into this incredible expansion, even revolution, in terms of this country recognizing the equal dignity of gay people. And I think he kind of said in Lawrence that people change, and like other people, like President Obama, he changed over time, and he really revolutionized the law in that way, and it's truly tremendous. I think at the end it was something he's very, very proud of.
Kenji?
Yeah, I guess, so first of all, thank you. It's great to be here tonight. And I want to begin by saying that we had the luxury of arguing over Justice Kennedy's vote for all these decades because Robert Bork was not confirmed, right? So I think we all need to remember how momentous, right, these picks are, because if Bork had been subbed out for Kennedy, then we would have seen a dramatically different jurisprudence, not just in the LGBT area, but in manifold areas.
But so for people who might say, I want you to go back to what you're going to say, but for the people who do say that all these contentious Supreme Court nomination fights started with Bork and the Democrats now get what they deserve, what you're saying is, well, yeah, but if had they not fought Bork, they would have never had Kennedy.
And in fact, we may be swapping out a Kennedy for a Bork this evening, right, or beginning.
Just imagine what the last number of decades would have been. So there was for the progressive liberal sort of standpoint, certainly from gay rights, it was pivotal that Bork's nomination was throttled. And
it's a great note, Ron, to what you were saying. I also want to say that even though he, was very concordant with John Roberts' term, this is an unusually conservative term for him, right? So in a way, he presaged, I think, what the court will look like, in the future, this particular term, where he voted with the 4 conservatives much more often than he did with the 4 liberals. So Roberts actually did become the swing vote in cases like the Carpenter case, the Fourth Amendment search and seizure case. And so we had a vision of what the court might look like if Roberts were the swing vote, and it didn't, from a progressive perspective, look that pretty. I will also say, with regard to sort of expanding on Kennedy's legacy, that as someone who works in the areas of civil rights and anti-discrimination laws that intersects with the Constitution, I would say that his LGBT rights legacy is obviously a huge legacy that he leaves behind him. But also with regard to things like the death penalty, and particularly with regard to abortion, I think that he really, really, kept, as both Ron and Robbie were saying, the center from moving too far to the right, and captured the sense of the country. I mean, a supermajority of the country, something like 67%, approves of Roe versus Wade. Approval or disapproval notwithstanding, I think that when he had the opportunity in 1992 to overrule Roe versus Wade, and was viewed as having, he and his colleagues, O'Connor and Souter, were seen as having been packed onto the court by Presidents Reagan and George H.W. Bush to overturn Roe versus Wade in part, that they sort of held the ground and said, regardless of how we would have decided this case in the first instance were it before us, stare decisis, the idea that precedent has to be followed, controls here, and therefore we are going to uphold Roe versus Wade. They made some significant adjustments to it, but the fact that they doubled down on Roe versus Wade means that the right to abortion is, as we understand it to be, the law of the land today.
Another case that he was instrumental in was the one that granted rights to detainees in Guantanamo Bay. Another case that you'd think, really? A conservative justice appointed by Ronald Reagan? Now, liberals and progressives are, I would say the appropriate word is freaking out about tonight. They'll be freaking out together soon watching it. Are they right to be freaking out? And I don't want to know so much, although I think the audience would want to know, who do you think is going to be appointed? I'm less interested in that. I'm interested in knowing who scares you the most. Who's the one that would trouble you the most if we found out at 9:05 is going to be the next Supreme Court justice?
Well, so, I think in response to both those things, one, I think people are right to be scared, right to be nervous, because I think it's easy to underestimate how radically the court could shift with just a shift of one vote. To go pick up on something Kenji said, yes, we got a little glimpse of what a future conservative court might look like with this term and some of the decisions, but I think it was only really a hint of what it could look like, and I think it could be much more extreme. If you have 5 united, cohesive, very conservative justices on the Supreme Court, the whole enterprise of the court, I think, will change. Right now, we look at these decisions, and we see bad things happen, and we ask, will the court step in to save us? Will it stop the travel ban? Will it stop partisan gerrymandering? Will it do these things to rescue us from failures of the political process? And sometimes the court delivers, and often the court disappoints. I think you're going to see that flip over exactly opposite with this appointment tonight if the person the president picks is confirmed. Because we won't just be asking, will the court save us from failures in the political process? We'll see a court on a mission to thwart progress. We'll see a court not just failing to intervene in the political process to prevent bad things, but actively intervening to prevent progressive legislation, to turn back what states are trying to do where states do something progressive. And I think the whole dynamic here will turn around on this appointment. As for which of the four, I think they're all finalists because they will all deliver on the mission that the Federalist Society and President Trump put them on, which is to reverse Roe versus Wade, to cut back our rights, to reverse the direction of the court. All four of them will do that. It doesn't really matter which one of them he picks. That's why they're finalists, because they will deliver the promise that President Trump made, Vice President Pence made during the campaign, that they would litmus test their picks and put some on the Supreme Court who would reverse Roe versus Wade.
But there's no Harriet Mears here, right? There's no one here that the Democrats could say, well, they're just overtly on their resume unqualified, and so therefore we have a chance here. I mean, you know, there is this argument that, look, elections have consequences, and this is something we should all remember in these presidential outcomes. And President Trump, oddly enough, for a guy that didn't go to law school and is not the most well-read American, actually knew this. He kept telling his base, you have no idea what I'm going to get you the greatest justices on the court. He knew the significance of this. So here he is, oddly enough, for a guy who has a gold toilet but a blue-collar sensibility, he's only bringing, you know, the best resumes. He's got the best resumes. I'm shocked that we don't have Elton John nominated. You're like, I mean, that to me is...
That would be better.
Yeah, definitely. Big improvement.
That was a lead-in for you guys.
Look, you know, going back to Kennedy, I think Justice Kennedy's idiosyncrasies were in a certain way his best quality in a crazy kind of way, and I certainly didn't agree with many of his decisions this term. But that sense of unpredictability acted as a moderating force on the court. And we had a justice on the court who people really didn't know which way he would go. It's damaging for the country and frankly damaging for the court to have a Supreme Court where you pretty much know going in which vote every single justice on the Supreme Court will take. That's not good. We've never had that before in the Supreme Court.
Is that true?
In our history? I mean, the history of the court has been much more moderating. People have changed their views over time. There have been coalitions. And to look at it this hard right, hard left, although I don't think the hard left is so hard, moderate left division is really very damaging and very troubling for the country.
Kenji?
Yeah, I think the closest analog, Robbie, and it may not be on all four, so you can correct me, but it does seem like the FDR court might have been something.
I was wondering
like
what
that.
you thought of that.
Because under the Hughes court, the idea was there was all this social welfare legislation that the Congress had enacted, and then the four conservatives on the court, known as the four horsemen of the apocalypse, right, kept voting with centrist justices, Justice Roberts and Justice Hughes, Chief Justice Hughes, to strike down the legislation. So things like the National Industrial Relations Act, or all this other kind of the National Bituminous Coal Conservation Act, all these cases get struck down as being in excess of Congress's power to strike down. And ultimately, FDR gets so angry at this conservative bloc that's striking down his social welfare legislation. I was thinking about this when you were talking, Ron, because this is what you're talking about, right? We could have a Democratic president, right? We have to look beyond this presidency to some future Democratic president and administration and what they will do. And then I think that's when this moment tonight is going to be really come home to roost, right? And we're going to realize that a lot of, for me, it's not so much the states, it's actually congressional power. What Congress is trying to do can be limited in the way that FDR's social welfare legislation was limited by an extraordinarily conservative court.
And in the dissensus term, they talk about it. The liberals keep referencing Lochner, which was the big case of that area. There's nothing subtle about it.
Let's start with some of the cases, and let's start with the Masterpiece Cake case. We'll start with Kenji. You may remember we talked about this briefly last year because it didn't make it up, right? So we anticipated we would see it. So this is the case where you have a Colorado baker. He's a master cake baker. He's so good at it that he's saying that the making of my cakes are really an expression of my First Amendment speech rights, an artistic right that I have. In addition to my faith-based principles, I'm an artist. I remember saying jokingly last year, this was my one joke last year, I said, so if he was a shitty baker, this wouldn't matter, right? Because it does matter that he's really good at this, because he's now saying I'm an artist. You can't make me speak this way to support this enterprise, this union. So he refuses to bake a cake for same-sex marriage, and the Supreme Court takes this up and decides this on narrow grounds. But tell us, what about this idea that a person has a First Amendment right to speak in a particular way, to express his or her art in a particular way, and to express his or her faith in a particular way? And even though the public accommodation laws and the non-discrimination laws are protecting same-sex couples and are giving them the constitutional right, an American citizen still could say, you can't make me do it.
Right. So I guess I want to begin by saying that the court really shies away from the free speech issue. So you're quite right to say this is a double First Amendment case. It's both a free speech case and a free exercise case. But the case was decided solely on free exercise grounds, right? So that's a really important point to make about this case, because it really shifted the lens away from Jack Phillips, the baker, and towards the Colorado Human Rights Commission or Civil Rights Commission that ruled against him. And it focused in particular on language that the commission used that said, you know, the use of religion to discriminate against other individuals in society is one of the most despicable uses of religious rhetoric there is, and it's analogous to religious justifications for slavery or for the Holocaust. Justice Kennedy, you know, writing for the majority, found this incredibly offensive and said this violates, right, the free exercise, right, of Jack Phillips, because clearly there was animus on the part of the board.
And that question showed it.
Against him. Exactly. I mean, they had other pieces of evidence as well, but that was the kind of smoking gun in Kennedy's view. So he said, you know, I'm going to decide this on very narrow grounds. I'm not going to decide anything else about this case other than the fact that when there is what he views to be sort of gross animus in the case that rises to that level, that this falls into a line of cases where if the government is, you know, legislating something in facially neutral terms, ordinarily, meaning that it doesn't sort of express, you know, use the word religion or name any religion in its enactment, then generally only the lowest level of review applies. It's known as rational basis review. But the one exception to that is when the government is actually acting in a way, although facially neutral in terms of the legislation, that betokens some kind of deep animus on the part of the government, then a higher level of scrutiny will apply. So the main precedent point is a case called the Church of Lakumu Babalu I against Hialeah, where municipal ordinance said you can't engage in animal sacrifice. It seems to be unexceptionable. But when they dig into it, they realize that the entire ordinance was enacted with animus against the Santeria, and the whole reason to create this ordinance was to discriminate against a particular sect of religionists who were engaged in animal sacrifice as part of their religious ritual. And so using that case, they said this is just like that case, because while on the surface it might seem to be just this innocent non-discrimination statute, the statements that were made by people on the commission suggest that there's an anti-Christian animus here.
So, and I want the two of you to join in on this, but I'm just curious, because I'm even confused about this, because where does this leave the baker and other people who perform services? For instance, there was another case in this term. The Supreme Court disposed of it very quickly with a florist.
Exactly.
Who was I think in the state of Washington. Florist says the same thing. I'm an amazing florist. And when I put flowers together, woof, I'm the best at it. And you can't make me make a floral arrangement for this. And the Supreme Court basically just said, go look at what we just said for the Colorado Baker case.
Right.
And you're just saying, you didn't really say that much in that one. So
well,
what's the instruction?
That's right. Yeah, so I think the instruction is a threshold matter if you're applying the Masterpiece Cake Shop precedent, is to say, let's dig through the record here. There's going to be a lot of fact-finding, digging through the record for things that look like animus, and it's unclear what that standard is going to be. So if someone said, oh, that person is, just a religious bigot, right? Well, it's going to depend on whether that was a governmental actor, and it's also going to depend on, whether or not saying somebody is a religious bigot is enough, right? If I say there's no religious right to discriminate and I'm the government, is that, going to be seen as animus? Probably not, right? Bigot, probably yes, right? So I think that that's the threshold question that they're going to have to answer. After that, we're in brand new territory, that, all those questions about is there a free speech right, these other questions about is there a religious right to discriminate, those are all still open questions. Is sexual orientation like race, because there was, as I think I mentioned last year, a case back in 1964 called Piggy Park, right, where there was a barbecue where the barbecue owner said, I don't serve African Americans out of my religious conviction, and the court just gave that the back of its hand. And I don't think that case would come out differently even with the court that we have today. I think that what's interesting is going to be to watch the court draw distinctions in between the race context and other contexts like sexual orientation.
Yeah. I think people will be shocked to hear this. Probably not. But sometimes the Supreme Court says things and they don't really mean what they say. So telling someone in the Flores case to look at Masterpiece Cake as a precedent for how you're going to decide the Flores cake is kind of ridiculous, because Masterpiece Cake is essentially a ginormous punt.
Yeah.
On the one hand, you have Justice Kennedy saying that this Baker, in these particular circumstances of the Colorado Civil Rights Commission, there's some kind of animus. On the other hand, you have him talking about making sure that gay people don't get treated as social outcasts, and getting the vote, shockingly to me, frankly, of Chief Justice Roberts in that opinion, which hopefully is meaningful. I very much hope it is. I don't know. And then on the other hand, you have him not deciding the free speech part of it. And in terms of the free exercise, who knows? I think all we do know is that there's going to be lots and lots more litigation about this in the years ahead. I litigated a case in Mississippi about a statute called HB 1523, which allows people in Mississippi not just to bake cakes or not just to not sell flowers, but to not give medical treatment to people, to not do counseling to kids in high schools. A hugely broad statute. We lost on standing grounds, but at some point it will be back there. And I don't know what the court is going to say. All I can think of, and I have to think that Piggy Park is important here, is I remember when I was a kid, I grew up in Cleveland, my grandmother telling me about her honeymoon in the South and pulling into towns with my grandfather and trying to check into a hotel and being told no Jews allowed. Yeah. There is no difference in my mind, and I hope the court will realize that, between that and what's happening today in Mississippi and in other places, and we cannot allow that to happen in this country ever again.
Yeah. And just to pick up on what Kenji said, I think this case is a punt, and unfortunately now it's a punt to a different Supreme Court. So I actually, if you read the opinions in this case, the Masterpiece case carefully, I think it gives you some reason to hope that if Justice Kennedy had stayed and the Colorado Human Rights Commission had run an appropriate process and it had come back again, I think there was a high possibility the court would have sustained an order requiring the baker to serve everyone without any right to discriminate based on religion against same-sex marriages. And so hard to know how it would have come out, and indeed when you read this opinion, I think you kind of thought, well, maybe Justice Kennedy is staying. Maybe he's writing this opinion, he's leaving this open. Surely he won't leave this open and then walk out. But he did. And so I think it's not just a punt, but it's a punt to a very different kind of Supreme Court that will decide this. And I think we'll wrestle, perhaps very unfortunately and unsuccessfully, with the kind of issues that Roberta was talking about.
So speaking of Roberta, let's talk about the California faith-based pregnancy center case. So this is a case that arises out of California. The state of California has a requirement that if you're performing any of these family pregnancy centers of any kind of dealing with teenage pregnancy, that you have a requirement to post announcements that there are low-cost alternatives where you can get a publicly funded abortion, and that this is required, that in these centers that you post this. And this Christian faith-based center brought a suit and said, again, under First Amendment grounds, they said, you can't force me to speak this way. We're here for a very different purpose. we're trying to stop abortions and to provide Christian families support, and we don't really want to be interfering by providing this other language that we don't agree with. And what happened in this case?
So the court said that that was okay, that the statute was struck down. What's interesting, going back to Justice Kennedy, is that Justice Kennedy wrote a concurrence, and he's again kind of obsessed with this issue. He implies that it was kind of anti-Christian discrimination that led the California, doesn't imply, he says it, that led the California legislature to pass the statute. So again, you have him with this kind of concern about kind of bias against Christians, and he concurs on that basis. I think the case is most notable for really two things. One, it's a very strong indication of something that was very strong this term, this threat of weaponization of the First Amendment. So you see it in Masterpiece Cake, you see it in the abortion case, and you see it in some other cases we're going to talk about, and you see the dissenters warning about it in their decisions. The other thing that's troubling about it is when you get into these kinds of contexts and you're kind of overturning legislation that really just provides for notice and public notice to the women who come in, how do you differentiate that, on the one hand, from the Casey decision, which required doctors performing abortions to say all kinds of things to women about the risks and what the fetus looks like, et cetera, which the court held was fine. So if you're performing abortions, you can be ordered to say certain things. If you're against abortions, you can't be ordered to say certain things. So neutrality principles are very troubling in the case. And again, what it says about whether the court's going to kind of go on to, you hear Ron warning about it, have this new era of overturning what everyone thought was perfectly ordinary kind of regulatory legislation, telling lawyers there's certain things they can and cannot say, telling doctors there's certain things they cannot say. As a gay person, I'm particularly worried about the case because I think it bodes very, very poorly for the statutes that are now being passed prohibiting gay conversion therapy in many states. I don't know how those statutes survive under this ruling. And again, it's a different court that's going to get these issues, but it's definitely going to be a new era.
Yeah, I think this might be the most Trump-era case of this term because fundamentally it's about the right to lie. That is, what these so-called crisis pregnancy centers do is they lie to women about the services they provide. They lie to women about what they're doing. They lie to women about the fundamental premise. And what happened here, as Robbie said, is the state passes a law that says, hey, you have to tell the truth. And the Supreme Court says, actually, no, you don't. You can continue to lie to women. You can continue to try to deceive them. You can continue to try to practice this deceptive practice. And you know, I think, as Robbie said, without any kind of veneer of neutrality around these different rules that are particularly prevalent in the abortion area. So I think, you know, it is a very scary precedent about what happens from here forward, particularly with a more conservative court looking at these efforts to regulate what people can and can't say.
So Ron,
Can I jump in?
Sure.
So the one sort of potential silver lining, although I fear that the opinion, as Robbie was gesturing towards, already takes care of it, but there are 18 states that actually require doctors to say false things to women about their pregnancies. So, and say that if you get an abortion, you have a higher risk of depression, which is not true. If you get an abortion, you have a higher risk of suicide, which is not true. If you get an abortion, you have a higher risk of breast cancer, which is also not true. So all these statements are untrue, but state law in these 18 states requires that physicians say that. So it could be that NIFLA, this case, could be used as a shield, right, by the physicians who don't want to say false things to their patients and they don't want to lie, to be able to assert against the state that's requiring them to lie, to, you know, not have to do so. The thing that's a little bit tricky about this is that the way in which the majority distinguishes the informed consent practices that Robbie was talking about. So I'm reporting, not endorsing here, is to say those were procedures. These are not medical procedures, right? And so there is a kind of picking and choosing, right, that goes on. So I'm worried in the same way that you are, but I don't think we even need to go to the LGBT context. I think we can stay foursquare in abortion and say, can this be used actually as a shield, right, on the part of physicians who don't want to have to lie to their patients about the consequences of abortion? And, you know, this language in the opinion might be a roadblock to that, but it's at least a hopeful direction in which we could take it.
Ron, so this for all of you here who bet in pools and offices on March Madness, or for professional football, when you bet on a friendly wager, the Supreme Court this term struck down any federal laws prohibiting states from legalizing sports betting. I didn't even think about this before.
Yeah.
That there was a federal law that prohibited states from doing this, and the Supreme Court struck this down under their Commerce Clause. Maybe you can explain this case, and why is it? Is there a carve out for Las Vegas and Atlantic City? I mean, how does that? Why is it? Why can they have sports books and Wisconsin can't?
Yeah, so in an otherwise depressing night, this will be a brief moment of lightness as we talk about sports and gambling. So good news on that. So, this case came from New Jersey, was argued before the Supreme Court as Christie versus NCAA, decided as Murphy versus NCAA. If you're from New Jersey, thank you for making that change. And the issue is, any of you may remember in the late 70s, early 80s, a bunch of states took steps to have kinds of lotteries and state-run games based on betting on NFL games. And the NFL was very upset by that, went to Congress, asked for legislation. Ultimately, in 1992, Congress passed something called the Professional Amateur Sports Protection Act, or as it's catchily known, PASPA. And PASPA said, if betting is legal in your state right now, like it was in Nevada, like it was for a particular kind of game in Delaware, Oregon, if it was legal in your state right now, you can keep it. But no state can change their laws about sports gambling to authorize sports gambling, okay? So it's a freeze. And sports betting was not legal in New Jersey. You could go to Atlantic City, you could bet on a lot of things, you couldn't bet on professional sports. New Jersey regretted that, said, hey, we want to make sports gambling legal, tried a bunch of times, lost a bunch of times under this law, and finally brought this challenge saying that the law was unconstitutional. And the Supreme Court agreed with New Jersey. Justice Alito, for a 6-3 majority, said that the Congress telling the state legislatures that they couldn't pass laws to authorize sports gaming was commandeering. It was the Congress making the legislatures do its will. And Congress can't do that. Congress could ban sports gambling in America if it wanted to, if it was within its Commerce Clause reach. It could regulate it, but what Congress can't do is it can't tell the state legislatures what to do about it. And as a result, now, the state legislatures are in a race to see who can legalize it. It's an interesting thing. Come the NFL season this fall, you're going to see sports gambling be legal in a number of states. The case is also interesting for sports gambling, that's interesting enough, but it's interesting for another reason, because it reinvigorated a part of the court's effort to strike down federal laws that try to regulate how states regulate things. And this could come into play from a progressive side if the Trump administration tries to crack down on sanctuary cities. This precedent might be very helpful to sanctuary cities in defending themselves. It might also be helpful as states and the federal government wrestle about marijuana legislation. There's actually a footnote in the opinion about regulation of marijuana. So good news, sports gambling, legal if you like to do that. Marijuana, sanctuary cities, maybe they get a boost out of this decision as well.
Kenji, unless you have something to add, I want to talk about the cell phone privacy case.
Yeah, so can I just say one thing on Ron's thing?
Yeah.
So this is, the notion of federalism, which is two sovereigns occupying the same physical space. So the states, occupy and have their sovereignty, even as they occupy the nation. And what Ron's talking about, I think, is exactly right. And there was, some liberal sympathy, right, for the opinion in that case. And I think that it derives from the idea of this anti-commandeering principle. And the anti-commandeering principle says, if the states are truly co-equal sovereigns within their space, the federal government can't sort of commandeer them, force them to either enact or not enact legislation, because if legislation is then enacted or not enacted, the people within that state don't know which bums to vote out. So you can either directly legislate and take your lumps for it as Congress, or you can, not do anything and let the states govern, but you can't use the states as a kind of sock puppet for your own legislative ends. Because if you use the state as your sock puppet in that way, then you as the citizens of New York don't know whether or not to vote out the people in Albany or whether to vote out the people in Washington, D.C. So that's the anti-commandeering principle, and it was, again, extended in this case from earlier cases that had dealt with nuclear waste disposal and earlier cases that dealt with the Brady Handgun Act, commandeering local sheriffs. So it's actually not particularly necessarily a partisan issue, but I think that one of the pivots that we see in the part of liberals is to say, well, if we have a Congress that's so antithetical to things like sanctuary cities, then maybe this is actually going to be helpful, because what's sauce for the goose is sauce for the gander. Okay.
So let's go back with you, Kenji, on the cell phone location privacy case. So if I'm in this case a robber, burglar with a gun, and I'm under investigation, apparently I have a Fourth Amendment expectation of privacy, right, for the police not to call my wireless company and to find out where I am based on my data on my phone. In this case, it's exactly what they did. Without a warrant, they acquired this package of information, what's called location data, and they were able to sort of triangulate and find him. And they did this, without a showing of probable cause and without a warrant. And the Supreme Court ruled that under Fourth Amendment, that the defendant in this case had about the same amount of expectation of privacy than if he was in his car or was in his home.
Exactly. And so this is actually an interesting case from a breakdown perspective, because Roberts joins the four liberals, and Kennedy is in dissent. So this is actually a harbinger, perhaps, of what's to come, in that Chief Justice Roberts can control certain, what I would call liberal outcomes, because this, to me, was upholding of the expectation of privacy. So this is going to be my one moment of levity. I'm actually usually much more chipper than this, but I'm a little bit dour tonight, so I'm sorry if I'm bringing you all down. But my one moment of levity is that this whole issue about cell phone or cell service location information comes about because a guy tried to rob a T-Mobile store, right? So the chief sort of notes the irony of this fact, as he goes through this case. But then he goes on to say, it's a really fascinating issue because there are precedents on both sides. So on one side, there are these early cases that say, if I give my information to a third party, so if I give a bank my information, or if I give the phone company my phone records, that I've voluntarily given that information over to a service provider, and so therefore that service provider can be forced to disgorge that information without a warrant, right? Because if I voluntarily disclose it to someone, I've essentially disclosed it to all the world, right? So I don't have a reasonable expectation of privacy in that anymore. On the other side, this is where those old precedents meet the technology. You have these cases where an earlier case in 2012 that talks about GPS devices, and then in 2014, the taking of a cell phone with all the data on the cell phone. And the justices there side with the defendant and say, no, you can't take that without a warrant because the GPS is actually a violation. It's a trespass on your property because it's attached to your car. And the case of the cell phone, there's just simply too much information on your cell phone. So that's not something that the framers could ever have contemplated. It's not what the justices in these earlier precedents had contemplated, and therefore they sided with the defendant. So this is siding with the latter line of cases rather than the former line of cases, and the chief saying, look, there is a reasonable expectation of privacy against having your cell service location information used, because you don't voluntarily give that up in any meaningful sense of the word. Like, anyone who's carrying a cell phone right now is giving up that information. So you don't volunteer to have a location device on you, a tracker placed on you by the government at all times. You're just trying to get cell phone coverage. And so that matters, right, with regard to what you voluntarily disclose, and takes this case outside of the ambit of those cases about disclosure to third parties. And then second, he says the reasonable expectation of privacy doesn't inhere, and this is actually citing older case law, doesn't inhere in a location. It's not the home per se. It's not a private place per se. It's an expectation that a person has about their privacy. And Justice Thomas wrote a quite virulent dissent saying that he didn't believe that there's any reasonable expectation of privacy whatsoever. So, Justice Thomas, for good and for ill, I would say, I think he has the courage of his convictions and his principles, really will say we need to go back to very first principles. At common law, the idea of a search had everything to do with trespassing on your property. It has nothing to do with, your person or your reasonable expectation of privacy. So we should get rid of that privacy jurisprudence altogether. So I think another thing this fifth vote is going to potentially offer, given that we've seen Justice Gorsuch's side with Justice Thomas on some of these issues, is a really hard tilt, right, on the court towards the right. That Justice Thomas will no longer be the voice crying out in the wilderness, but he will have 2, 3, maybe even more votes on these very, very deeply originalist takes on the Constitution.
So for the sake of levity, we should all hope that the sports betting case leads to marijuana legalization in New York. And we can all have much more fun, like the way they do in California. We can have much more fun at this. But I think this case is really an example, and you're seeing this more and more, the sales tax case is similar this term, of the court grappling with modern technology. And I'll be frank about this, the court hasn't been particularly fast or sophisticated about its understanding the very fundamental ways that technology has changed people's lives and expectations. There's jokes, about the justices many of whom were quite old, like using flip phones and not understanding smartphones. But slowly but surely, I think they're starting to get it. And they're getting the degree to which the enormity of the data flow in today's technology really changes people's expectations about what people should have access to and what they shouldn't. And frankly, not only have the courts been slow, the legislatures have been slow as well. This is going to be a really developing area going forward, and we see it with the Facebook controversy today. People don't really fully understand the degree to which your information is everywhere, and to what extent are we really consenting to that on a day-to-day basis.
And if I could just briefly, I agree with what Kenji and Roberta said. I agree with the outcome in Carpenter. I agree it's a bright spot with an asterisk, which is just a little bit of privacy rights for privileged people. So over the past several terms, the court has allowed unprecedented kinds of searches in homeless shelters, allowed people who use cars as their homes not really have the same status as homes. But if you own an expensive one of these, that turns over a lot of data to a provider, like perhaps Chief Justice Roberts does, then you have a privacy right, right? And look, I think it's right. I think it reflects a technological reality. I agree with everything that should be said, but I just hope as we grow and expand these privacy rights, we understand that different people have different kinds of privacy rights, and this is a privacy right of people who own $1,000 phones. And that's great. They should have that privacy right, but other people have other expectations of privacy in their lives with less privilege, and their rights need to be vindicated too.
This strikes me as one of those cases that's confusing for people who think about, well, what do conservatives believe, right? On the one hand, well, aren't conservatives against crime? So if you're against crime, what you're really saying is, why would we grant this guy an expectation of privacy? He was trying to rob a T-Mobile store, right? And so at the same time, we think of conservatives saying, we don't want the government to intrude on my lives, right? And so it does give you that confusion, like, what do conservatives believe? Because this case, in some ways, would drive them nuts. Because on the one hand, because they apparently, was it in the majority opinion or in one of the concurrences, one of the justices said, well, we're not talking about national security concerns, which is to say that if you're the Tsarnaev brothers, the Boston Marathon bombers, those guys had cell phones. And nobody on the Supreme Court would think that they needed to just demonstrate probable cause to get a warrant in order to get the information off of those cell phones. So they're saying in certain kinds, and then there's this other thing called real-time crimes. I'm not even sure exactly what that is, but I guess that means if something is happening right now, we just don't have the time to go. I mean, there are criminal lawyers. My friend Linda Imes is here. She could explain it to us. But in these matters, right, that it does give you the sense of confusion, how complicated this is, because what do they believe? Speaking of the, Roberta, let's talk about the online sales tax case, which we can, for tonight, call the Amazon case.
That's what it was. So.
It just so happens that for those of you who were shopping online all these years, you got a break. you didn't pay sales taxes on many things because the rules were very clear that unless the retailer had a store or a warehouse in your state, it had no actual physical, I think they call it brick and mortar. If they don't have a brick and mortar presence, we're not obligating them to collect sales tax, so good for you, consumer. And by the way, this is a prejudice to the small business person in that state because they happen to have to pay rent and they have to collect tax. And it's so much easier to sit at home in your pajamas, which we could have done tonight, and buy something at home.
While you're sports betting.
And sports betting. You could use your whole life. All the cool stuff now happens online. And so this case said, it said what? No, that in fact we should require retailers that are making online transactions. We should force them to actually collect, whether they have a store or location or not. And this would even the playing field with the small businesses.
So again, this is, I just intimated, this really is another example of the court kind of dealing with the fundamental changes that technology has wrought in our society, and the enormity of Amazon and what it represents and how many people use it. And particularly, the state at issue was North Dakota. You have to assume in a state like North Dakota, a lot of people are buying a lot of stuff on Amazon because it's just easier than driving 100 miles to wherever the store is. But in a certain way, economically at least, I think you have to see this case as kind of a fight not between kind of like stores and taxpayers, but between one kind of store and another kind of store. So you have the Walmarts of the world that are brick and mortar stores. They just happen to have also a lot of conservative donors behind them, and they really, really didn't like this regimen because they had to pay taxes, and the Jeff Bezoses of the world, Trump's sworn enemy, did not. And there was perceived to be a lot of unfairness there. So the court kind of abandoned this brick and mortar rule to say that we're going to be more kind of in tune with the modern economy, and we're going to require these stores to pay it. What was so interesting to me when I was reading it is if you look, in the cases based on Commerce Clause, but Justice Kennedy talks about it being due process as well, in the requirement, the older requirement of having a location in the state being a due process issue. When you think about personal jurisdiction cases, however, which is when a plaintiff, and in this case typically it's an injured party, has the ability to sue a company, there the court has very much gone in the opposite direction. There, in cases like Daimler and others, the court has said, no, there not only do you have to have brick and mortar, but you actually have to be at home in the state. So think about it as a hypothetical. If some poor schnook in Dakota buys something on Amazon and gets horribly injured by it, and he wants to sue Amazon, he's got to sue them in Seattle. He may have to pay sales tax on it in North Dakota, but he can't sue them in North Dakota in most circumstances. He has to go to Seattle, where Amazon is at home. So there's really a dichotomy in the court's jurisprudence on this. I'm not sure if they fully understood that when they were writing the decision, but I guarantee you that they will, because someone's going to raise it with them.
Ron, let's move on to the partisan gerrymandering case. I find this interesting, and you're the perfect person for this. So we know the rule is that you can't redraw the voting maps of a state to prejudice a minority or a race.
Kind of.
Okay.
Yeah.
But this case says, this is something else. It's saying, look, under political lines, we can redraw this, and this is the difference between, it's really about, does your vote count in a way? You think of voting block districts as like a square or a rectangle. We don't think of it as a salamander. Although even in New York, I think Jerry Nadler, there's some voters in Staten Island. I don't know how the hell they're there. But they're even here, I think we have some weird things that were redrawn.
Definitely Brooklyn.
Definitely in Brooklyn. Like we're going, how is that possible? So that has been redrawn. So the Supreme Court says, look, when it comes to politics, this is something else. That, again, elections have consequences, and if you lose, you got to expect to some degree the state legislators are going to run around and change the voting districts to prefer their party.
Yeah. So the question is to what degree, and how far is too far? And that's a question the court's really been wrestling with a couple of decades. And in this case, from Wisconsin, the legislature had gone very far. And the simple way to think about how gerrymandered Wisconsin is is if any of you watched something called the 2016 election, you know that Wisconsin voted evenly, pretty much, between the two political parties. Donald Trump won the state by less than 0.2%. And yet that same election, the outcome of the Wisconsin state legislative elections was 65 Republicans won, 35 Democrats, okay? That's how gerrymandered Wisconsin is, okay? Even election, 65-35 outcome. So the question is, when is that too much? How much gerrymandering is too much? Since the nation's history, gerrymandering is a practice named after one of the founders, Elbridge Gerry, who helped write the Constitution, was a state official in Massachusetts, did this 200 years ago. People drawing districts for partisan advantage is as old as the republic itself. But is there a line that goes so far that kind of strips democracy of its meaning, that strips voters of their real chance to have their preferences heard? That's the question the court's been wrestling with for a long time. In 2004, in a case called Veith versus Jubiliner, the court divided 4-1-4 on this question with the swing vote, no surprise, Justice Kennedy saying, there's a line that's too far, but it's not here, and I don't know exactly what it is. And so people thought this Wisconsin, 65-35, it would finally trip the trigger for Justice Kennedy. He would say, this is too much. What the court ultimately did, and what wound up being essentially a unanimous opinion, was they said that the plaintiffs in this case didn't have standing to bring this claim. This is the kind of outcome that drives non-lawyers crazy. Why does the Supreme Court hear this case that basically doesn't rule? But basically the issue is the plaintiffs brought a claim that said, our power as voters was damaged by the way this districting map works statewide, where Democrats were part of the 35 out of 65, very bad for us. And the court said, you got to come back to court. You got to show that you personally were harmed. You were in a district that was really affected by it, so on and so forth, right? And as a result, sent the case back home. Interestingly, though, there was a second claim. The second claim in the case was this practice of extreme gerrymandering violates people's First Amendment rights of association. Democrats have a right to get together and be Democrats together, to form a party, to elect people, to potentially win elections, to run candidates. And the plaintiffs did a bad job of bringing this claim, but the court left open the possibility in a future case this kind of claim could win. Justice Kagan wrote a very powerful dissent in this, or concurrence. She agreed there was no standing, but wrote a roadmap for how to bring one of these First Amendment claims and said, this is how you do it. These are the kinds of plaintiffs that could bring it. This is what you need to show. And again, a bit of an appeal to Justice Kennedy. Her opinion is just a bunch of like, Justice Kennedy should think this, Justice Kennedy should think that, Justice Kennedy should think that. Pretty good sign that she had no idea Justice Kennedy was quitting when she wrote this opinion. And so lays out a map. What his successor will do, whether or not he or she will be similarly uncertain about this, hard to know, and probably not. Last thing I want to say about this, which is this is also an example of the point I was making earlier about how we could flip from a reality where we hope the court will save us, but doesn't, to where the court really hurts us. And this is what I mean by that. All across the country, people, on a bipartisan basis, are trying to get rid of gerrymandering by urging state legislatures to pass nonpartisan anti-gerrymandering commissions to draw lines without politics. And states have done that. In 2015, the Supreme Court considered whether or not that was constitutional. And on a 5-4 vote, upheld the constitutionality of these nonpartisan reform commissions, 5-4. One of those 5 was Justice Kennedy. And so will his replacement vote the same way? Will we go from asking the court to fix bad districts to seeing a court ban states from fixing bad districts? That's a possible outcome here.
I'm pulling a President Trump here. I want to left you in all suspense because I held off on the Muslim travel ban until now. Could have started with that. You would have thought that was the way to start. So building on the suspense, Kenji, let's talk about that. So this was iteration number 3. The first 2 attempts at the travel ban were challenged in the court and invalidated. This is the third one. President Trump, I don't know, he had his own Ron Klain whispering in his ear, and he said, some smart guy, woman, said, why don't we just call it a vetting procedure for terrorists? Let's just say let's call it what we think it's going to be, that the court and everyone will understand. It's not about Muslims. It's about vetting procedures for terrorism. So they rename it, and it goes to the Supreme Court. And the Supreme Court, I think one of the justices even said, look, our president is intemperate. He says weird stuff. But the reality is he's our president, and he's responsible for national security. And this is a test of his presidential powers. This is the executive branch. And we're not going to second guess him. If he thinks this is necessary to protect the country, then this is his call. 5-4.
Right. Yeah, so that's right. And so just a little bit of more context as we go into the guts of the opinion. This travel ban 1.0, you said this was 3.0, came about after President Trump's inauguration, when he enacted a very sort of sweeping ban that actually restricted people from coming into the country who had been flying in. And so you remember all that chaos in the airports. This was blocked by the courts, and so he came up with travel ban 2.0, which again was blocked by the courts, and so he came up with travel ban 3.0 right when the travel ban 2.0 was expiring. And then travel ban 3.0 was more subtle, right? And he actually, as we'll see, got major points for the revisions that he made. And so it excluded individuals from 8 countries. A number of those the majority of those were majority Muslim countries.
But North Korea and Venezuela.
North Korea and Venezuela were also added to them. And against this, there were 2 claims that were brought by the challengers. One was the statutory claim, saying that he lacked authority under the Immigration and Naturalization Act to create this executive order or executive proclamation. And second was a constitutional claim, an Establishment Clause claim. So with regard to the first one, I'm going to dispense with that really quickly. The statute gives the president wide discretion in order to exclude individuals from this country whom he believes or she believes are detrimental to the interests of the United States. And the court interpreted that to say this exudes deference, it said, in every clause, right, towards executive authority. The countervailing statutory argument was a claim that you can't discriminate on the basis of national origin with regard to the issuance of visas. And so that seems to be pretty clearly in tension with what President Trump did. But in opinion, this 5-4 opinion, or the majority opinion by Chief Justice Roberts says, well, the first provision, giving him wide discretion, controls admissibility. And so that's really the critical issue. That's 1182F. And then the non-discrimination provision only applies after the admissibility determination is made. So once you've determined that you're going to admit individuals from a certain country, let's say Canada, you can't distinguish among individuals who are applying for visas on the basis of their national origin, right? But if you exclude individuals from an entire nation, then that actually doesn't run afoul of the non-discrimination provision, because the non-discrimination provision only applies to the issuance of visas, not to the threshold and antecedent question of admissibility. So if that seems like threading the needle, it is, right? And so that's cutting it pretty fine, but that's the statutory outcome. With regard to the Establishment Clause claim, this is discrimination against individuals of the Muslim faith. The court first said this isn't discrimination on its face, so I introduced that idea of facial discrimination earlier on, so I could advert to it again here, which is to say, would a proverbial Martian looking at the statute be able to tell that this is discrimination? And the answer is no, right? Because all it says is the names of the countries. It doesn't indicate that these are majority Muslim countries that are covered by this proclamation. So it's facially neutral in the sense that you can't, from the face of the legislation, see that there's animus against a particular religious group. Nonetheless, that case that I was talking about earlier, the Lukumi Babalu I case about animal sacrifice, should probably hold some sway here, given that there's pretty clear evidence of discriminatory intent. And the Supreme Court essentially lets President Trump off the hook here by saying, a number of things. First of all, it says this was an iterative process where there were revisions, and so the third 3.0 order, dropped 3 countries that were majority Muslim, added some countries that were not Muslim, and therefore that softened the notion that there would be religious animus here. Second, it said that there was a program of exemptions, and third, there was a program of waivers from the requirements of the proclamation. So there are statutory or executive exemptions from the coverage of the proclamation, and then there were also waivers that were granted on a case-by-case basis. What's really interesting is that Kagan and Breyer, right? Breyer wrote a dissent that Kagan signed on to, did something really temperate in that they said, we really question whether or not these exemptions and waivers, which look really good on paper, are actually being, carried out, faithfully. And to the extent that they're not being carried out, and these are simply sort of paper tigers that are being created, that is evidence that the real thing that was underlying this was religious animus. And I think that was a really deliberate attempt to court, Justice Kennedy, right, to sign on to their view and get him into the fore so it could become a majority. And then they obviously failed on that. And then Justice Sotomayor, with Justice Ginsburg, joining her, wrote a kind of fire-breathing opinion that said this is essentially like the Korematsu opinion back in 1944 that justified the internment of individuals of Japanese ancestry. And the majority responded to that by saying, well, no, Korematsu is clearly antithetical to our historical notions of constitutionality. And so it repudiated, this is a very thin silver lining there, the Korematsu opinion and a majority opinion for the first time. But nonetheless, Sotomayor said you're replacing one grave error with another grave error because this is nothing other than religiously based discrimination.
So when the president says, well, yes, Professor Yoshino, most Muslim countries are not on the list. I didn't ban. I mean, if you look at the majority of Muslims around the world, they're not on my list. Why do you think this is about my animus or enmity towards Muslim? How do you know I'm not really worried about terrorism? I'm worried about we want to make America great again. Can't have terrorism.
Right. So I think I would say a couple of things in response to that. I mean, the first thing is to say that national security can be used in this context, in the context of foreign affairs, to cover any kind of executive order. So we should really look askance at broad claims about national security. And then second, we have a really well-oiled procedure for figuring out when pretextual discrimination, which is when there's no facial discrimination, but there's discriminatory animus underlying a governmental enactment, is in place. And that well-oiled machinery says you can look at the legislative and administrative history, you can look at the sequence of events leading up to the state action, you can look at collateral evidence that is being produced, you can look at under-inclusiveness and over-inclusiveness. So we have a really, including in this Lukumu Babalu case, a really well-established set of procedures. And if you look through all those procedures, you can tick every single one of those boxes for President Trump. He sold this to his base, as a campaign promise, as a ban on Muslims. He later, after he became president, because a lot of people drive a wedge between Trump the candidate and Trump the president, he later as president said, I'm just going to double down and I'm done with this political correctness and, I want to think about this as a Muslim ban and so I'm not going to kowtow to it. He spoke approvingly of the Korematsu decision, right? And so I think that we have enough evidence to support this notion of discriminatory intent behind the statute. And one of the interesting things, right, is to say, why is the court straining so sedulously to find governmental discrimination in the Masterpiece Cake Shop case and not in this case, right? So, I sort of I close where I began, right? Which is why I set up that case in the way that I did in order to lay out some of the key precedents, which were clearly not being followed here.
That was good.
Well, the only thing I'd add, I mean, I obviously agree with that really brilliant explanation of it. The only thing I'd add is this case also includes my nominee for worst opinion of the term, which is not the majority opinion, but Justice Kennedy's concurring opinion. So as his farewell act at the Supreme Court, Justice Kennedy wrote this concurring opinion in the case that said, can't do anything about this whole travel ban thing, but the Supreme Court's not the only enforcer of the Constitution. The president should take the Constitution seriously. I sure hope the president will read the Constitution very carefully. I sure hope the president will really, really, really take this Constitution thing very, very, very seriously. Which is kind of like the Pamplona Street Department putting up "Please walk carefully" signs and expecting the bulls to obey them, okay? I mean, it's just not gonna happen. The idea that Justice Kennedy's giving like advice to Donald Trump to be a more rigorous constitutional president seems pretty preposterous as an opinion. And I think it really, I mean, in some ways, it's kind of a sad and somewhat fitting end to his tenure on the court, that at some of these key moments, he didn't really step up. He didn't really do what he had to do. He kind of waved around a bunch of fancy words and hoped it would make a difference. And that's sadly what happened in this case.
Yeah, no, I agree. In a term of depressing decisions, this is definitely wins the cake, no pun intended. In her fire-breathing dissent, Justice Sotomayor cited my fire-breathing amicus brief, which talked about this concept of animus cleansing. Can you remove animus from a presidential act just by having version 3.0 and removing all the evidence in the text itself that shows that it's based on anti-Muslim animus? This is a very depressing opinion, because we all know what was at stake here. We as Jews all know what was going on here. This was applied to us in the past too. And to have the Supreme Court do this and this and this, especially Justice Kennedy, who was able to see the animus at the Colorado Civil Rights Commission, who was able to see the animus in DOMA, and I can say as the lawyer who litigated that, it was a lot less obvious than the animus in the Muslim ban, is really disturbing, both in terms of constitutional jurisprudence, in terms of this animus jurisprudence which he developed, and in terms of whether this court is going to step up to, overtly prejudiced acts by this president.
While we have you, Roberta, I want to go back to what you said before about weaponizing the First Amendment, because we can maybe speak about that with more clarity in connection with the public sector unions case. And maybe you can explain what you mean about weaponizing the First Amendment, because we all have an image of how it's normally used, right? We think of it in terms of like the famous case of, say, Cohen versus California, where you're against the Vietnam War, you walk into a courthouse, I believe it was, you wear a jean jacket with a patch that says, "Fuck the draft," right? You're taking a political position, you get arrested for disturbing the peace or whatever the rules are, and you say, "I have a First Amendment right to say this stuff." And you may think it was crudely said, but it's an important political point that I would like to make. So it seems, I suspect, different the way it was applied in the California Pregnancy Center case. And in the public sector union case, again, you saw another use of the First Amendment in a way that we normally don't see it, right? The general rule had been that for public sector unions, police, fire, teachers, you don't have to join. But even if you don't join, you still have to pay your fair share for any time the union negotiates on your behalf and wins you benefits, wages, something that it makes your life better, improves your job. Otherwise, you'd be a free rider, and nobody likes a free rider. So we make you pay that piece. And in this instance, the idea was to say, the plaintiff said, no, I don't like the politics of my union. And everything that they do has a political dimension, and they're speaking for me, so it violates my First Amendment rights, and I don't have to pay. And the Supreme Court agreed with that.
So there are two incredibly, in my view, disturbing features of this term. One is this weaponizing of the First Amendment, and again, that's exactly right. We in this country do all kinds of things, like pay taxes, which people say I could object to what my taxes are being paid for, and I have a First Amendment right for that not to happen. And under this kind of a theory, that's at least a plausible claim that no one for many, many years, even Justice Scalia himself, did not think was a plausible claim, because governments have to act. And if everything is speech, because people in acting are expressing opinions one way or the other, then I don't know how government does anything. So it's incredibly disturbing for that reason. It's clearly an attack on the public sector unions. Ron would know this better than anyone, that have been such a bulwark of Democratic Party organizing and fundraising over the years. And perhaps equally as disturbing, and you see this over and over and over again, you saw it in the sales tax case, you see this kind of willingness to overrule precedent in ways that we have not seen from the court in quite a while. This is not a new issue. This issue of free riding in public sector unions and agency fees and whether they're okay has been litigated at the court many times, and it's been upheld over and over and over again as a kind of necessary function of public sector unions, because after all, if everyone could kind of not pay their dues at all, then they would just not pay their dues and there'd be no unions who would be able to collectively bargain for the workers in the first place. That is what the dissent pointed out in this case. In his majority opinion, Justice Alito comes up with arguments for why it's okay. The conservatives on the court had been building up to this. They kind of inserted criticisms of the older precedent multiple times up to the years, and this was kind of the ninth inning. This was the punchline where they finally did it. And their attempts to say that what today makes it so different, why this decision now should be overruled, at least in my view, are not particularly convincing. And it shows, let's think about it for a second. Conservative justices are supposed to revere precedent, right? Edmund Burke conservatives, you like the past, you like precedent, you don't believe in change. But you have some named conservatives on the court right now who seem to be very willing to overturn precedents that have kind of shaped public policy and shaped how people act for many, many years. And that bodes very risky for this country.
Yeah, if I could just say one quick thing about that. The precedent Roberta's talking about, the Abood case, was decided in 1977. It's a 40-year-old precedent. It was a unanimous decision of the Supreme Court. Even Justice Rehnquist joined, Chief Justice Berger at the time, joined this opinion that said you could make public employees pay dues to a union, okay? Unanimous, 40 years old. All across the country, people have written contracts based on the idea that this is good law, okay? So we're going to see President Trump tonight name someone to the Supreme Court. That person's going to go before the Senate Judiciary Committee in a few weeks. They're going to hold up their hand and they're going to say, I respect precedent. And they will offer a bunch of generic promises to respect precedent. And they will offer a bunch of principles about respecting precedent, okay? Every single one of the 5 people who voted to overturn Abood gave similar testimony when they were confirmed before the Senate Judiciary Committee, including Justice Gorsuch, who said, as a Supreme Court justice, I take precedent very, very seriously, and a year later voted to overturn a 40-year-old precedent that had been a unanimous decision by the Supreme Court. So when you hear tonight's nominee give a general sweet rub to precedent in their hearings, don't you believe it?
Speaking of tonight's nominee, Walt, can we see what's on there right now? As we 5 minutes before the president comes live. Let's see what this looks like. And then we'll still do some talking. I'll take some questions.
Break my neck if I
take a few questions from you. Settle down. Let's see what this looks like.
Looks like.
There we go.
It looks like that. All right, so we'll wait. We've got still another 5-6 minutes or so. Let's take some questions from the audience.
Just before we start, you know, Ron's exactly right. I mean, this is about, obviously, public sector unions, but this debate is also about Roe v. Wade. The undercurrent in all these decisions is Roe v. Wade, and which is obviously ever present in what you're going to hear tonight.
So here's a question from the audience. Justice Scalia was confirmed 98-0. With that said, why today does the confirmation feel more partisan rather than a question of whether the judge is qualified? And I sort of hinted that when I said there's no Harriet Mears here. On paper, credentials, the president keeps saying, we have great people, great people. He's probably right on academic credentials and merit. There is merit. We said a moment ago when Ron was talking about partisan gerrymandering, we said, well, you know, this has been around from the very beginning, right? Elections have consequences. Maybe elections, again, have consequences. And so if you bring up, if you have, when it didn't happen with Bork, but it did happen with Scalia. It didn't happen with Garland, right? Garland, a real tragedy. The guy was a centrist, by the way, and had what I think everyone in this room on the stage thinks is one of the great resumes. I would consider it a Ron Klain resume. So what about the answer to this question? 98-0, nobody said a peep about Scalia.
Well, I'll start. I mean, first of all, many of the senators who were part of that 98 have said it was the worst mistake they ever made, including my former boss, Joe Biden, who said the 30,000 votes he cast in the Senate, this is the one he'd like to have back. Wow. And elections do have consequences, but the members of the Senate were elected also. And 48 Democrats in the Senate were elected, and Susan Collins and Lisa Murkowski were elected, and they promised their voters they would be pro-choice when they went to the Senate. So that election has consequences too. So look, if you ask me what's happened to this process, I do think, I don't want to be obsessed with this, but I do think Bush v. Gore is a big part of this. You look even after Bork, there were a lot of non-controversial confirmations. Since Bush v. Gore, we've had 4 or 5 of the closest confirmation battles in American history. In 120 years, only 10 sitting justices have had more than 30 no votes cast against them. 5 of those 10 sit on the Supreme Court right now, all 5 after Bush v. Gore. Including Justice Alito, Justice Gorsuch, who had 46 no votes. So, President Trump somehow kind of won the election. He's going to pick this person, but the senators won elections too. Their views, their philosophies have a right to be heard in this process, and I certainly hope they will.
Why do you think, another question, why do you think Kennedy chose to retire now? Now, there are people who speculate that the president had been so nice to him and had kept whispering in his ear, I'm going to pick one of your former clerks. So Ron Klain clerked for Justice White for 2 terms. That was another thing I forgot to tell you, clerked on the Supreme Court. That's the B side of his resume. Would that be something that Justice Kennedy would say, really? One of my clerks, another one? That's so cool. Is that how he would respond? It sounds so silly to me that that's the reason to retire.
I don't know why Justice Kennedy retired. I do know that he was picked by a Republican president. Maybe he feels some obligation to let a Republican president pick a successor. Certainly Justice White, who I clerked for, who became much more conservative than President Kennedy, who appointed him, nonetheless retired the first year Bill Clinton got elected president, and thought that his seat should be filled by a Democratic president. Maybe that's what Justice Kennedy's thinking. Hopefully someday Justice Kennedy will explain what he's thinking. Hopefully someday he'll explain what he thought all term this year. But I don't know. Maybe there's no real way to know, I don't think.
What would happen if the court overruled Obergefell? What would happen to families and kids? Now, is that a question that you two even entertain as a possibility?
Sure. I mean, the chief compared in his dissent the Obergefell decision, which is a 2015 case that said that same-sex marriage was constitutionally required under the equal protection and due process clauses of the 14th Amendment. He said that this is comparable to the Lochner decision and the Dred Scott decision, right? So these are 2 of the most reviled decisions. Lochner was a classic social Darwinist, devil take the hindmost. Let's, raise up, economic libertarian theory over, any kind of hours regulation that seeks to provide a kind of humane baseline for the conditions in which people work. And Dred Scott, of course, is the one that was saying, the African Americans, did not have standing to sue because they were not citizens of the United States. So, if you put, Obergefell in the company of Lochner and Dred Scott, you can already see which way the wind is blowing, right? So he's just looking for a 5th vote. Whether or not stare decisis, I mean, that's what makes this conversation about stare decisis, which I find really timely and rich. So I think that I read the Janus case, the Union case, exactly the way, Robbie, you did, which is I just read it as we're talking about a 1977 opinion there. The Roe is 1973, so can we overrule a 40-year-old precedent? And the factors that the court goes through would be the factors that it would go through for Obergefell as well, and those include things like, has this been a workable decision? Is there a reliance interest on this? Is there a change in doctrine? Is there a change in fact? And on all 4, one could make the argument that both Roe and Obergefell are endangered. Indeed, someone like Scalia would say if you have a bad precedent, of course he's not on the court anymore, but he used to say if you have a bad precedent, better to get rid of it early before reliance interests have kicked in rather than to overrule it. So it's an interesting question about which is more likely to be overruled, Roe or Obergefell.
Robbie, do you imagine yourself standing again before the Supreme Court saying, for the love of God, I was just here a few years ago, and now you're bringing me back. You can't possibly consider overturning this.
An answer to the question, that the gentleman asked about why other prior judges had 98 votes, and that probably won't be the case here. The answer to that question is going to be determined by the person who is confirmed in the seat. There's just no question about that.
Wow.
And, I'm very concerned on the one hand, there's a high level of public approval of marriage equality nationwide, but there's also a high level of public approval for women's right to choose. In moments like this, I get a little religious. I pray to God that I never have to be in front of the Supreme Court making that argument again, and mostly on behalf of my son, who's 12 years old and believes he has two mothers who are married. But there's no way of knowing. Unless you can read into human minds, there's no way of knowing.
This is not a question. I would never normally read a comment, but will here, because I don't want to feel like I failed anyone. Can you bring in some conservative perspective opinion for balance? I added the question mark. You forgot to put it in. There it is. I can't answer that question. So
you brought in a conservative for balance.
here's the balance, the bully pulpit of the President of the United States. In a moment, Ron and I will leave you. You'll see I'm on MSNBC. I'll be on CBS News Radio. Robbie and Kenji have agreed graciously to stay with you. So when this is over, they'll add some comments, and then you can take some more questions from the audience. I don't want to feel as if, it's an interesting question, right? We go through this all the time. Law schools are filled with liberal thinkers, for the most part. Intellectual magazines are filled with liberal writers. Fox News is special in its own way. It's avowedly conservative. Let me just say, I didn't, in composing this, we've asked, the people, we normally bring in journalists. So over the years, we've had Adam Liptak from The Times, Dahlia Lithwick from Slate. We had from NPR, Nina Totenberg one year, Dan Abrams from ABC. They're all liberals, and they all work for these major news outlets. And I wonder whether I really need to do a better job of calling Bill O'Reilly and seeing if he needs a gig, because I think he might. Let's see if I can take one more question, then I know Ron and I need to leave. Well, this is such an interesting, because I don't think anyone will believe. In your opinions, do you believe that the conservative-liberal split on the court is a partisan one or a well-intentioned difference of opinion on jurisprudence? In other words, maybe it's not political after all, that it is an understanding of the Constitution the way the Federalist Society would say, textualist, originalist, and that this is a friendly disagreement among people who went to law school. Without Bush, for you, it would be impossible to imagine this, because the lens is Bush v. Gore. But again, is it possible that this is an academic exercise and not a political one?
Well, go ahead, you go first.
I was just going to...
Oh, there.
All right, good night, everyone. This was wonderful, thank you. Come back again. Thank you.
I'm going to go over here a second.
My fellow Americans, tonight I speak to you from the East Room of the White House regarding one of the most profound responsibilities of the President of the United States, and that is the selection of a Supreme Court justice. I've often heard that other than matters of war and peace, this is the most important decision a president will make. The Supreme Court is entrusted with the safeguarding of the crown jewel of our republic, the Constitution of the United States. 12 days ago, Justice Anthony Kennedy informed me of his decision to take senior status on the Supreme Court, opening a new vacancy. For more than 4 decades, Justice Kennedy served our nation with incredible passion and devotion. I'd like to thank Justice Kennedy for a lifetime of distinguished service. In a few moments, I will announce my selection for Justice Kennedy's replacement. This is the second time I have been faced with this task. Last year, I nominated Judge Neil Gorsuch to replace the late, great Justice Antonin Scalia. I chose Justice Gorsuch because I knew that he, just like Justice Scalia, would be a faithful servant of our Constitution. We are honored to be joined tonight by Justice Scalia's beloved wife, Maureen. Maureen? Thank you, Maureen. Both Justice Kennedy and Justice Scalia were appointed by a president who understood that the best defense of our liberty and a judicial branch immune from political prejudice were judges that apply the Constitution as written. That president happened to be Ronald Reagan. For this evening's announcement, we are joined by Ronald Reagan's Attorney General, Edwin Meese. Ed? And Ed, I speak for everyone. Thank you for everything you've done to protect our nation's great legal heritage. In keeping with President Reagan's legacy, I do not ask about a nominee's personal opinions. What matters is not a judge's political views, but whether they can set aside those views to do what the law and the Constitution require. I am pleased to say that I have found, without doubt, such a person. Tonight, it is my honor and privilege to announce that I will nominate Judge Brett Kavanaugh to the United States Supreme Court. I know the people in this room very well. They do not stand and give applause like that very often, so they have some respect. And Brett's wife, Ashley, and their two daughters, Margaret and Liza, have joined us on the podium. And thank you and congratulations to you as a family. Thank you. Judge Kavanaugh has impeccable credentials, unsurpassed qualifications, and a proven commitment to equal justice under the law. A graduate of Yale College and Yale Law School, Judge Kavanaugh currently teaches at Harvard, Yale, and Georgetown. Throughout legal circles, he is considered a judge's judge, a true thought leader among his peers. He is a brilliant jurist with a clear and effective writing style universally regarded as one of the finest and sharpest legal minds of our time. And just like Justice Gorsuch, he excelled as a clerk for Justice Kennedy. That's great. Thank you. Yeah. Judge Kavanaugh has devoted his life to public service. For the last 12 years, he has served as a judge on the D.C. Circuit Court of Appeals with great distinction, authoring over 300 opinions which have been widely admired for their skill, insight, and rigorous adherence to the law. Among those opinions are more than a dozen that the Supreme Court has adopted as the law of the land. Beyond his great renown as a judge, he is active in his community. He coaches CYO basketball, serves meals to needy families, and, having learned from his mom, who was a school teacher in D.C., tutors children at local elementary schools. There is no one in America more qualified for this position, and no one more deserving. I want to thank the senators on both sides of the aisle, Republican and Democrat, for their consultation and advice during the selection process. This incredibly qualified nominee deserves a swift confirmation and robust bipartisan support. The rule of law is our nation's proud heritage. It is the cornerstone of our freedom. It is what guarantees equal justice. And the Senate now has the chance to protect this glorious heritage by sending Judge Brett Kavanaugh to the United States Supreme Court. And now, Judge, the podium is yours.
Mr. President, thank you. Throughout this process, I've witnessed firsthand your appreciation for the vital role of the American judiciary. No president has ever consulted more widely or talked with more people from more backgrounds to seek input about a Supreme Court nomination. Mr. President, I am grateful to you, and I'm humbled by your confidence in me. Thank you. 30 years ago, President Reagan nominated Anthony Kennedy to the Supreme Court. The framers established that the Constitution is designed to secure the blessings of liberty. Justice Kennedy devoted his career to securing liberty. I am deeply honored to be nominated to fill his seat on the Supreme Court. My mom and dad are here. I am their only child. When people ask what it's like to be an only child, I say, it depends on who your parents are. I was lucky. My mom was a teacher. In the 1960s and 70s, she taught history at two largely African-American public high schools in Washington, D.C., McKinley Tech and H.D. Woodson. Her example taught me the importance of equality for all Americans. My mom was a trailblazer. When I was 10, she went to law school and became a prosecutor. My introduction to law came at our dinner table when she practiced her closing arguments. Her trademark line was, "Use your common sense. What rings true? What rings false?" That's good advice for a juror and for a son. One of the few women prosecutors of that time, she overcame barriers and became a trial judge. The president introduced me tonight as Judge Kavanaugh, but to me, that title always belonged to my mom. My dad went to law school at night while working full-time. He has an unparalleled work ethic and has passed down to me his passion for playing and watching sports. I love him dearly. The motto of my Jesuit high school was men for others. I've tried to live that creed. I've spent my career in public service from the executive branch and the White House to the U.S. Court of Appeals for the D.C. Circuit. I've served with 17 other judges, each of them a colleague and a friend. My judicial philosophy is straightforward. A judge must be independent and must interpret the law, not make the law. A judge must interpret statutes as written, and a judge must interpret the Constitution as written, informed by history and tradition and precedent. For the past 11 years, I've taught hundreds of students, primarily at Harvard Law School. I teach that the Constitution's separation of powers protects individual liberty. And I remain grateful to the dean who hired me, Justice Elena Kagan. As a judge, I hire 4 law clerks each year. I look for the best. My law clerks come from diverse backgrounds and points of view. I am proud that a majority of my law clerks have been women. I am part of the vibrant Catholic community in the D.C. area. The members of that community disagree about many things, but we are united by a commitment to serve. Father John Ensler is here. 40 years ago, I was an altar boy for Father John. These days, I help him serve meals to the homeless at Catholic Charities. I have 2 spirited daughters, Margaret and Liza. Margaret loves sports, and she loves to read. Liza loves sports, and she loves to talk. I have tried to create bonds with my daughters like my dad created with me. For the past 7 years, I have coached my daughter's basketball teams. The girls on the team call me Coach K. I am proud of our Blessed Sacrament team that just won the city championship. My daughters and I also go to lots of games. Our favorite memory was going to the historic Notre Dame-UConn women's basketball game at this year's Final Four. Unforgettable. My wife, Ashley, is a West Texan, a graduate of Abilene Cooper Public High School and the University of Texas. She is now the town manager of our community. We met in 2001 when we both worked in the White House. Our first date was on September 10th, 2001. The next morning, I was a few steps behind her as the Secret Service shouted at all of us to sprint out the front gates of the White House because there was an inbound plane. In the difficult weeks that followed, Ashley was a source of strength for President Bush and for everyone in this building. Through bad days and so many better days since then, she has been a great wife and an inspiring mom. I thank God every day for my family. Tomorrow, I begin meeting with members of the Senate, which plays an essential role in this process. I will tell each senator that I revere the Constitution. I believe that an independent judiciary is the crown jewel of our constitutional republic. If confirmed by the Senate, I will keep an open mind in every case, and I will always strive to preserve the Constitution of the United States and the American rule of law. Thank you, Mr. President.
We're just going to take a few questions. Roberta Kaplan had to leave due to a client emergency. So we have time for just a few questions. Please feel free to just raise your hand, and I'll repeat the question because I have a mic and you don't. In the front. Yeah, so I think it's a tough question for me to answer. The question was, what can an individual citizen do when the Supreme Court tilts in the way that we're seeing it tilt, right, against them, given that there is no appeal that can be taken from the Supreme Court and they are independent bodies? Is that a fair rendition of the question? So one of the things that's fascinating about that question is, and this is going to be a false rescue, I should advertise it as such, is that there is one remedy, of course, other than the justices overturning their own opinions for a bad Supreme Court opinion, and that's a constitutional amendment, right? And in many, many other nations, right, the redress for a bad constitutional decision or a court that you disagree with is to change the Constitution itself. Because, however, in our country, and this is the false rescue part, the Constitution is so radically difficult to amend, requiring both a supermajority of Congress and a supermajority of the states. It has only been amended 27 times in our nation's entire history. And so that avenue, which should be the classic democratic check and the ultimate democratic check on a negative constitutional decision, can't be exercised, right? So one of the reasons why I think that we need to think about the way in which we approach our Constitution as a living Constitution is because the primary mechanism through which the Constitution should live, through constitutional amendment, isn't available to us. And so therefore, I think that that puts pressure on the justices to understand the Constitution expansively and to update it as a living document because alternative avenues are not there. Now, I realize this is not helping you that much, right? Because I'm saying the one obvious answer isn't really available to us. There's some other non-obvious answers though, and they both deal with the other branches of government and they deal with the other level of government that we have. So the other branches of government are obviously the executive and the legislative branch, right? So we have elections, for those branches. They're known as the political branches for that reason. And those elections are going to be ongoing, regardless of which way the court tilts. Also, the court is not as counter-majoritarian as it may seem, right? Insofar as even though the justices have life tenure during good behavior, they actually are replaced at a rate of one scholar's estimated 22 months, apiece. That's gotten longer as the longevity of the justices themselves has gotten longer. But elections matter in part because if you elect a different president, you'll get different justices. If you elect a different Senate, you'll get different justices. The final thing I'll say is that I mentioned federalism earlier, which is the idea that there are state governments and that there's the federal government, right? The federal judiciary sits on top of both, but there's a lot of running room, right, where the state courts, for example, can build on top of the floor that the Supreme Court has set. So, for example, the Supreme Court has said, individuals with disabilities, for example, only get the lowest level of review, right? And so discrimination against individuals with disabilities can often fly, under the radar. But many state courts have said, under their own state constitutions, we're going to build above that floor. We're going to hold ourselves to a higher standard with regard to this. And so the states become the locus, right, for those rights in an era when the federal Supreme Court is not. Yes, in the middle. Mm-hmm.
Do you think that played into his nomination, and do you think his opinion on that could possibly dictate?
Yeah. So the question is, Kavanaugh has made statements about questioning whether or not a sitting president can be held to account, right, for high crimes and misdemeanors under an impeachment standard, or under, I suppose, if we're talking about the judiciary being indicted, right, while in office. Do I think that played a role in the president's decision to appoint him or to name him? I mean, I can't answer that. What I can say is that one of the hallmarks of Judge Kavanaugh's jurisprudence has been extremely strong deference for executive power, right? So this is part and parcel of his brand. In other words, what I'm trying to say is that the comment they're reporting is not a stray remark. It's actually part of a broader jurisprudence, right? Whether it's therefore strategic for this particular president, given the legal travails that he's going through to select him as a justice, I don't know. Yeah. Yes. Hi. Yeah, so it's a great question. So one of the answers that I didn't give is an answer that President Roosevelt gave, Franklin Delano Roosevelt, back in the period that I was talking about, where the justices were striking down the social welfare legislation that he was championing under the New Deal. And his solution was the so-called court packing scheme, where he said, for every justice who reaches the age of 70, I'm going to appoint another justice to the Supreme Court because of claims about workload. But really what he was trying to do was to swamp out the four horsemen of the apocalypse by having a new number of appointees. So he wanted to raise, under one conception, the number of justices from 9 to 15 and create a 9-6 majority or a 10-5 majority in his favor, right? Giving himself some running room for justices that wouldn't vote in the way that he had predicted. So this court packing scheme was a real piece of legislation, and it led Owen Roberts, who was one of the justices in the middle, to switch sides, and his switching to vote for the social welfare legislation rather than against it was known as the switch in time that saved 9, meaning the 9-member court. However, because Justice Roberts switched in the way that's Owen Roberts, not our chief, switched in the way that he did, it was not necessary for the court packing scheme to actually be enacted, and it withered on the vine. I think what you're referring to, though, is that the number of justices in the Supreme Court is nowhere defined in the Constitution, so this is actually a matter of statutory discretion, and Congress has, from various times, gone as low as 5 to as high as 10, right, justices on the Supreme Court. I'm not a big fan of court packing. I think that it casts, serious doubt on the legitimacy of the court in ways that are long-lasting. I would also remind us that even though FDR sort of dodged a bullet and won the day and didn't need his court packing scheme due to the switching of Justice Owen Roberts, that the court backing scheme itself sort of withered on the vine. It was never enacted, in part because the wind had been taken out of its sails, but also because the worry was that it would precipitate a sense of a constitutional crisis of a president trying to pack a bench. So I don't think that is a solution. I would go to the solutions that I offered that operate more within the tradition of the system of looking to the other branches, looking to the other layer of government and the state governments rather than a court backing scheme. Okay, one last question. Yes, in the back. I don't think anything is off limits, but I do think that the justices or the judges who are up for confirmation can decline to answer with regard to matters that can be before them, right? So I think that the justices cannot be forced to answer a question that they can be adjudicating in the future because of exactly the kind of litmus tests that could be applied to them. So I think that their records have to speak for themselves. I think the good thing about Judge Kavanaugh is that he has a really, really voluminous record as a precedent reference, and so the need for that kind of direct questioning may be less, right? Precisely because that record exists. But in principle, I agree with Greenhouse's point, and she's someone I deeply respect as well as a constitutional scholar. But the question of what can be asked is different from what must be answered. Thank you so much.